Good morning. We'll call this hearing back to order, and I'm going to turn it over to Mr. Butler for just a minute to remind everybody of a few things.
Hey, thank you, Mr. Chairman. Appreciate everybody's attention this morning. I did want to bring up one thing that we did cover at the pre-hearing conference and that we really didn't see a lot of yesterday, but as you recall, there was some discussion at the pre-hearing conference about an encouragement on cross-examination of groups, at least, combining their cross-examination with witnesses. The idea being that if, say, one lawyer who is of a similar interest with another lawyer could talk about it and perhaps combine cross-examination, that maybe we could move this hearing along a little bit, and we really didn't see much of that yesterday. So the only reason I speak this morning is to just encourage you, if you could, help us with this and try and see if you can't get together to some degree and perhaps combine some cross-examination questions with one lawyer. The main reason being, I'm sure everyone's looked at the cast of characters, and we've got quite a road ahead of us. And obviously, we are limited on the other end by the General Assembly in terms of the time that we have both for this hearing and to issue an order. So once again, we just encourage you, if possible, to attempt to combine your cross-examination questions. Would be much appreciated, I know, by the commissioners and honestly, I'm sure by everyone else. Thank you, Mr. Chairman.
Thank you. And I remember well talking about that, and I remember well yesterday that didn't happen much. So I would heed the recommendation or the expectation from the hearing officer on that, because we're going to encourage you to keep this thing moving. We're on a very aggressive schedule, and we don't have time for the same question to be asked over and over again, and we'd like for you to combine your witnesses. So take note. All right, we've got Mr. James. You're still under oath, and it's time for commissioner questions. Commissioner Howard.
Thank you, Mr. Chairman. Good morning, Mr. James.
Good morning, Chairman.
James,
Commissioner.
it's not confusing, but could you explain to me the role of the 3 ORS monitors on site? Now, in relation to what Mr. Jones's responsibility is?
Well, I think I'd start by saying I think we've heard through the course of some of the testimony here that ORS is at the site and has access and staffing at the site frequently. First of all, we're about 2 miles away from the site. We're housed in a trailer that you have to access through 2 security gates to get access to. I am typically not out at the site. Mr. Jones comes out once a month, and one of my team would accompany Mr. Jones, and Mr. Solt will be our primary representative out at the trailer, out at the site, and he was the one that would primarily attend those plan of the day meetings. And about 2014, when I was promoted to Director of New Nuclear Development, that is when we decided we needed a little more access to some of the meetings and some of the activities that were going on at the site. We were ultimately allowed to attend those plan of the day meetings. Or we still continue to be denied access to the consortium meetings, where you did have the leadership talking about issues of the project. We request repeatedly to attend those meetings. I think the response was that ORS attendance there would chill the conversation. And we believe that, I believe the NRC was allowed to attend some of those meetings, but we were not. The work that goes on is directly related to what we ask. We're out at the trailer. Mr. Solt is probably reviewing documents. And if he has a question, the convenience is that they'd come to the trailer and they'd answer our questions if they could make those folks available to us. But I think that's generally how ORS function. And Mr. Jones had access to a reading room in Chicago. He'd also look at the information and help develop the questions when he would come to the site. Throughout the years, we've had leadership roles there from Ms. Powell. I believe Mr. Seaman Wynn was there for a while leading our effort. We also had Mr. George Kokolis that was part of the Energy Office, which came over, that did try to help us in some regard there as well. Then ultimately, Ms. Powell came back on board, and now we have Mr. Ryder Thompson heading up that effort out at the site.
I think one of the requirements by statute is attending on-site meetings with project managers. Have you ever been denied that? Do you go to on-site meetings with the project managers?
And project managers, in that regard, is intended to mean that we do plan of the day meeting, and those are project managers. And the other project managers are the ones that SC project managers. And through time, we did start meeting with WEC representatives and CBI representatives out at the site as well. But it should be clear that there's a lot that we did not have access to. Mr. Gene Solt, through many requests of his own, that he wanted to have unfettered access to the site. He has over 35 years of experience of working on nuclear construction sites, working on coal sites, and felt that he should have the same level of access that the NRC would have. And as the director of the department, it was getting a little out of bounds of what the law required. It seemed to present some safety concerns to me, and so I think we just left it there.
Well, another one is performing weekly on-site reviews with construction documents. Did you do that, or were you denied that access?
No, sir. And in 2014, once again, we had a long list of documents that we wanted to see on an ongoing basis. We have a file cabinet that's locked out at the site, and it's loaded with binders and information. SC was very forthcoming with anything that we asked for. We would develop a weekly agenda, and a lot of those documents would be updated, and that would be some of the source of the questions that would generate some of the agenda items. And Mr. Jones would have access to the same information through the secure reading room, and so that when he would get to the site, he didn't have to sit and run through those many binders to try to get up to speed. They were very accommodating in that regard.
When you did your on-site, whatever, performance or whatever, what did you do? What did you do with this information? Did you submit a report?
For the most part, our information did get rolled into our quarterly report that we filed in response to SC&G's quarterly reports. And what you would see is that SC&G would write their quarterly report, and then we would generate a response typically. And the issues, Mr. Jones would generate a section it would call construction challenges. And Mr. Soap would provide some input there as well. But that is where the information we gathered from what we saw in the documents and what we talked to the representatives out at the site, that's where we would reveal them.
Well, I was under the impression that SC&G did their quarterly reports, turned them over to you, you reviewed them. From that document, you came up with your quarterly reports and presented it to us. Is that basically the way the system was?
That's my understanding. Our quarterly reports were posted, and I believe they were incorporated into a revised rates filings to make sure they were at the commission.
Well, are things like Mr. Jones's challenges in the quarterly report?
Certainly.
Okay.
We had an entire section dedicated to that.
Let's go back. We talked the other day about the Friends of the Earth representatives having 4 issues. Either one could be a reason for disallowing payment, so to speak, or disallowing revenue. Do you remember that conversation?
I can recall some of it, certainly.
Well, I'm going to go from memory, but there were 4 points that he said, that the witness said that either one of them could have been used to disallow, future funding. And those 4 things were, number 1, was mismanagement of the project. And number 2, chaos on the job site. Number 3, a misunderstanding of the regulatory electricity regulations, regime. And number 4 was not understanding the Base Load Review Act, and misrepresenting and misunderstanding the Base Load Review Act. Mr. Jones said that information did not get to the commissioners. Do you remember that conversation, Mr. Jones, exchange between Mr. Jones and myself?
I'm having a little trouble to recall. I recall those items coming from Dr. Cooper's testimony, and I recall Mr. Jones saying he did not believe that there was chaos on the site, and I'm not clear on some of
Well, the element on mismanagement, I asked him, I said, Mr. Cooper, Dr. Cooper, why did you give this information to us? And he said no. Do you recall that exchange?
I was not present entirely for Dr. Cooper's testimony, but my response to you would be mismanaging or managing of the project is not an ORS's responsibility. That's beyond what N&D responsibility, even ORS. It's up to the utility to manage their project. We've given strict instructions. We don't manage the company. The company makes decisions. Those decisions have impacts. We bring those impacts to the commission, and they decide the result.
Well, I guess maybe I don't understand what you're saying about mismanagement, but my thoughts were the project was mismanaged. Then that could have led to some unwanted expenses, so to speak. And so then you come in for cost recovery of unwanted expenses due to mismanagement of the project. Do you not agree with that?
I understand your question there. We did not believe that the project was being mismanaged while we were in the course of reviewing the project. I think that's Mr. Jones' testimony. We found that there were concerns, there were issues, there were remedies to those issues. SC&G applied those remedies. Some just were not successful. Now, looking back in hindsight with the information we have, and I believe Mr. Jones' testimony was that he believes he was misled, and if you mislead somebody, you're not properly managing the project.
Then I will follow up. I think Commissioner Hamilton asked you yesterday, and I'll follow up after this exchange. You know of any information that was not passed on to that you had that could affect the project, that it was not passed on to the PSC?
Clearly, what we're certain about is the Bechtel report, the Bechtel assessments, and the Bechtel schedule information.
Well, you might answer my question, but I guess I find it hard to understand that you did not know that Bechtel was on site. Now, granted, you might have not had presentations on the site, but there was one of the points of the Bechtel report was poor morale. And they encouraged to do Employee of the Month or whatever the hell the case was to offset that. Did you not see any sign when you went on the site of poor morale? You didn't have any conversation around a Coke machine or anything about poor morale on the project?
We don't engage the workers at that level, but I believe we've put in our reports, certainly Mr. Jones has provided testimony somewhere along the line here that morale had somewhat waned when CB&I was the lead contractor on the project. When you had, we can say when Shaw was the lead, morale had waned, productivity was down. CB&I came on board. Everybody thought that was a great idea. CB&I had been an outstanding performer on the site. They were responsible for building the bottom head and containment vessels, the rings and all, and they had been doing stellar work out at the site. So when the idea that CB&I would come on board, we believe, motivation changed in a positive direction. Then over time, that motivation once again began to wane. And then Flora comes on board. And I believe Mr. Jones said you could see a clear change in morale for the positive. But once again, as you fall behind schedule, it's just going to have a downward pressure on morale.
One of Mr. Jones's recommendations that I didn't see, and I'll speak personally for myself, is one of his recommendations, and it was near the end of the whole project, that stop work completely on Unit 3. Don't do anything on Unit 3. Put all your resources, all your talent on finishing Unit 2, because Unit 3 was out of the mix for any kind of production credits. Do you remember that?
I don't know that I recall that being a position that ORS put forward. We talked about that a great deal internally. But once again, it's not our job to manage the project.
Well, that was Mr. Jones's recommendation.
I'm unfamiliar with that, yeah.
Okay. Mm-hmm. Thank you, Mr. James. Mm-hmm. Thank you, Mr. Chairman.
Thank you, Commissioner Howard. Commissioner Hamilton.
Thank you, Mr. Chairman. Good morning, Mr. James.
Good morning.
I trust you rested well.
I tried.
Mr. James, I'm going to follow up on some of Mr. Howard's questions.
Certainly.
I think that the entire commission, I feel like, was kind of shocked yesterday when we heard from testimony of not only you, but Mr. Jones, of the restrictions that were placed on the on-site people. And I noticed in your testimony you said you were here when they opened the doors, and I was too.
Certainly.
So the ones of us that were here, and part of the time of hearing that we approved the construction of VC Summer 2 and 3, one of the highlights that was presented to this commission was the fact that we would have people on site from ORS that would know exactly what was going on, would be qualified and trained, and would bring that information to the commission. Well, in the 9 hearings we've had, we haven't been told that you were restricted in what you could do on site. We hadn't heard that before. And it's really a shock to know that you worked under the condition that you did when really you didn't really know too much of what was going on, did you?
Well,
You knew what they told you. You didn't know what you saw.
I think that's the case in anybody we regulate. We know what they tell us. But I didn't think it was a secret that we, as I said yesterday, the role of monitoring the project really limits us to monitoring the quarterly reports. That's what was envisioned in the BLRA. We were well beyond the bounds of the BLRA, I believe. And then once again in 2014, we said the schedule information in early 2014, SC&G came to us and said, we can't provide you any more schedule updates. And we won't be able to provide you any more schedule updates until Westinghouse is finished with the schedule. So our immediate response was, well, how in the world are we going to tell the commission the status of the project? Our primary responsibility is to tell them about the schedule and the budget. And if you don't give us an update, we can't tell them where they are on those 18-month window, whether it's 16 months or beyond the 18 months. We can't do that. Their response was, well, we can't. We're not getting it from Westinghouse either, Anthony. And even if we did give it to you, it wouldn't be of much value because it's in being re-baseline. We immediately sent a letter to the commissioners, to the commission, and informed you guys, hey, we're not able to do half of what we're assigned to do because we can't get the schedule information.
Have you got a copy of any of those letters that you sent to the commission?
We can certainly rustle those up there.
Chairman, I'd like to see those letters.
Mm-hmm.
Okay, we will get those letters as a late filed exhibit number 34.
Yeah, they were in the March-May time frame, and we followed that up with an allowable ex parte because our former executive director said you got to get before the commission and tell them what's going on. And that's when Mr. Jones and I came and pretty much said what the letter said and gave you a list of construction challenges at that time.
So if what you're saying, until 2015, you were pretty well pleased with what was going on.
We were not pleased. There were challenges that we wanted to make sure everyone knew about. We thought there were remedies to some of those challenges. And once again, we've been in support of the nuclear units all along. I strongly believe, as the Director of Energy Policy, that diversity of fleet, it's key. We're not building any hydros anymore, not building coal anymore, and certainly doesn't look like we're going to build any nuclear units in South Carolina. So everybody's putting their eggs in this natural gas basket. And, woe be on to us today that something again happens on the Gulf Coast or something happens with fracking.
Thank you, Mr. James. Appreciate your testimony.
Thank you, Commissioner. Other commissioners. Commissioner Whitfield.
Thank you, Mr. Chairman. Good morning, Mr. James.
Morning, sir.
I want to kind of, at least the first question, a little bit of where Commissioner Howard and Hamilton both were. I would share particularly what Commissioner Hamilton just said. I think it was the impression of this commission. We knew there was a trailer out there, as you've cited. I think with us not being allowed to go on site because of ethics rules, I'm talking about commissioners and commission staff, as one of them told Mr. Jones yesterday, you were our eyes and ears out there. And I think the I don't know that I'm speaking for every commissioner, but I think the general thought was that you all had an office trailer out there, and that at least 2 or 3 ORS staff people reported to that trailer every day, and that there was a lot more daily interaction, if you will. And now, we're learning that you're only able to inspect or get what they give you, so to speak, which is, and you had to be escorted. We've learned a lot here yesterday about how things actually were between ORS and the company on site out there as to what we thought they were. I'm talking about the commission. Certainly. But in that regard, you may have heard me question Mr. Jones yesterday, and again, rumor and innuendo really have no place in a place like this, but I addressed some of that with him yesterday, and he laid some of that to rest. So I would ask you the same question. Did you see any of in your appearances out there, did you see any of the abuses that he and I discussed yesterday, such as non-productivity, people sleeping on the job, taking excessive amounts of time to do a simple project, fraud, abuse, and downright theft? Did you see, are you aware of any of that? Not only did you see it, did you hear of any of that?
We had certainly heard some of that. I don't know through just conversations along the way or through some media outlets. I don't know, but when we're there, we're escorted around the site. We saw people working hard.
And you have the big vest on, and you're clearly identified as ORS.
I like the vest. I thought we did not want to wear an SCNG vest is the way it started. We wore SCNG vests and SCNG hats, and we just didn't think that was right. So we asked if we could have our own. Everybody knew when we were coming on site. But what we saw were hardworking folks on the site.
You had an exchange with Commissioner Hamilton about not being able to get the schedule for long periods of time. And if I could, let me go back with you, because being one of the original ORS members, let me go back with you just a minute. Mr. Jones, I think it was established, and he and I discussed this, came on with ORS in 2011. Yes, is
correct.
That correct? And when did Mr. Gene Salt, when did he come on?
Mr. Salt was already a part of ORS.
Before Mr. Jones?
I'm not entirely certain there. Mr. Jones was a part of ORS as part of the electric and natural gas department under John Flitter, and also worked as part of my team for many years. He actually came along when there was the energy assurance work that was through the the Obama administration. So that might have been before Mr. Jones.
You're talking about Mr. Salt now.
Mr. Solt, yeah. I'm not entirely sure. But he was a part of our rates and regulatory team at ORS and did a lot of work in energy assurance.
Energy assurance, at least back to 2010, right?
At least 2010.
That sound okay. That gives me an idea. All right, well, there was another witness ORS had in the original case, and I apologize to you for not digging through my testimony, but I can't call his name. He was from Georgia.
Mr. Mark Crisp.
No. Him too, but there was another one before him that was in the original case. He was a consultant.
We had a team of maybe 5 or 6 consultants at that time. Mr. Crisp led that consulting team. There were a host of witnesses. I can't recall their names.
Testified, I think, in the original case. But nonetheless, was there some... Did Mr. Salt, was he around when that team you're talking about in the original case, Mr. Christ and the man from Georgia who I can't recall his name right now?
I don't believe so.
So I guess what I'm trying to get at, was there some continuity of that institutional knowledge information from day one to Mr. Salt and to Mr. Gary Jones?
Certainly. Mr. Crisp stayed on as our consultant after the baseload case, and the continuity went from Mr. Crisp to Mr. Jones. Okay,
so Mr. Crisp would have been that person who, from the beginning, carried the baton, if you will, to where we are now, to Mr. Gary Jones and Mr. Salt.
And Mr. Salt is always reported up to our lead out at the site, which I had said had been Miss Powell at some time. It's been me at some time. It's been Miss Powell again at some time, and it's Mr. Thompson. But he's always, for the most part, been a part-time employee, and he's retired.
I was going to ask, is Mr. Salt still with ORS in any capacity?
He's still a part of our team, I believe, until next month, though. We're going to... He's only hung around because I've asked him to stay, so he's been an outstanding asset to ORS and to me personally.
So that continuity was carried, if you will, with Mr. Mark Crisp.
And you always had Mr. Salt in the background that is very knowledgeable of construction projects.
Okay, so going forward, but Mr. Salt, who was critical out there, won't be with you anymore going forward.
And yes, sir.
Okay. Let me shift gears just a little bit to you, Mr. James, if I could. You testified yesterday about ORS's position on the optimal plan and talked about what those rates would be for ratepayers. Are there any recent developments, and I'll let you define recent, any recent developments that might affect your proposal of the adoption of the ORS optimal plan? And recent could be the last week or two. You define it.
Yeah, the only recent development that's not reflected in my testimony, and will be reflected in other ORS witness testimony, is the the alternative proposal I believe Dominion has made.
And that was going to be my follow-up. Yes, in light of that.
Mm-hmm. In light of that, ORS continues to support its plan. We believe our plan is the best plan for South Carolina ratepayers.
Well, thank you, Mr. James. Thank you, Mr. Chairman.
Commissioners, other questions? Commissioner Williams.
Good morning, Mr. James.
Good morning, sir.
I just want to make sure I understand your testimony, your position regarding the allegation of fraud against SCENG. Is it your position that SCENG committed fraud on this project?
I use fraud strictly in the terms that are defined in my testimony. where fraud includes concealment, omission, misrepresentation, and non-disclosure.
Okay. And tell me where you believe that concealment, misrepresentation, and non-disclosure started.
From what we know, it surrounds the fall of 2014, where we know now that SC was seeking to get some assistance in looking at the project status, looking at the schedule, looking at the budget, or looking at the schedule, just the project status. That was ultimately where they hired Bechtel. We were not aware of that. And they ultimately filed a petition in March of 2015, omitting that information concealing that information from us. And then secondly is that we've learned that their own internal team had performed. They did a presentation, and they also did a report that showed that the cost that they were presenting might have been much higher. Those are two events that we believe are material, and they align with the definition of fraud.
Okay. So you believe that the company committed fraud when they didn't tell you that they hired an outside consultant to complete an assessment?
I believe I would say that was just unfortunate, but to file the petition and ask for an increase in rates or a budget and a schedule without revealing that is where I would link it to.
Okay, so the fraud was when they filed a petition without indicating that they hired Bechtel to perform an assessment.
Yes.
Okay. And you also believe that the company committed fraud when they didn't reveal that they had a team conduct an analysis that showed a production factor and costs that were different than what they filed in the petition.
Yes.
Okay. And it's your position that there was nothing ORS was empowered to do, or there was no tools ORS had in the toolbox to find out that information as it existed at the time?
That's correct. We don't know what we don't know.
Okay. So essentially, ORS was impotent or powerless to prevent what happened in that regard, in terms of uncovering the Bechtel report and identifying that there was a different analysis performed by SC employees than what was presented in that petition.
We were unaware of it.
Okay, well, that's not my question, sir. My question is, was ORS powerless, or were they prevented from uncovering that information at the time?
Prevented.
Okay, and they were prevented. And your position is that the company actively prevented ORS's uncovering of that information.
That's my testimony.
Okay, thank you, sir. I want to move on to the multiple plans that have been presented. In ORS's analysis of their plan, was there any consideration of whether or not the company would be at risk of going into bankruptcy?
Those conversations were had. That's a better question for some of our financial witnesses. But my understanding is that we kept that on the forefront, that any plan we would put forward would not harm the utility in a manner that would cause them to file bankruptcy.
Okay. But that's just an analysis. That it's not certain that if that plan were to be approved, that the company would not indeed go into bankruptcy.
And as I've learned through some of those conversations, the goal was to make sure that SC would not have an impairment. And I believe that's what we focused on. But I also learned that we don't get to decide whether they have an impairment or not.
Okay, who decides that, sir?
The company decides.
Okay. And so essentially it's a company decision.
It's a company decision.
Are you aware, or is anyone at ORS aware of what South Carolina's energy future would look like if the company went bankrupt?
I don't know the answer to that, no. Okay. It can't be good.
Okay. Well, what makes you say that? That it can't be good?
Well, a failed utility, a financially weak or a failed utility, will require some revenue stream from somewhere to make it whole. And their only source would be ratepayers.
Okay, so
that then rates would go up.
So it's possible that even with the approval, if it were approved, of ORS's plan, which, if correct me if I'm wrong, you believe is the best option for South Carolina ratepayers.
Yes, I do.
Okay. That it's possible that even if that plan is approved, that the company could go into bankruptcy. Is that correct?
My understanding is that they could have an impairment, and that can be different than a Chapter 11 filing.
Okay. And let's just say they decided to go to choose bankruptcy as the course of action, the best course of action for the company, which they are entitled to do, right? Is that a yes?
That is correct, yes, sir.
Okay. And that if that were to happen, that it's very possible that ratepayers would pay a higher rate than what ORS is proposing in their plan.
That would be my expectation.
Okay. Thank you, sir. No further questions.
Thank you.
Thank you. Commissioner Urban.
Thank you, Mr. Chairman. Good morning, sir.
Good morning, Commissioner.
Just to follow up on your earlier testimony, would you clarify for us when you first learned that Westinghouse could no longer provide SCE&G with a revised or updated schedule for construction?
I'm going to say that was January 2014. I think that's the last one we received was January 2014. So we went through all of 2014, and I believe SCE&G said they got a preliminary schedule in the fall of 14, which was approved in early 15, which was the basis for their 15 request for a modification of the schedule in the budget.
Did that not raise red flags with ORS staff that were monitoring this project to go that entire year almost without any kind of schedule?
It's a yes is the answer. But we always found ourselves, if you look at the baseload review order, ORS's responsibility of monitoring the schedule is really tied to the 146 milestones that the commission approved. We really have no authority to tell Westinghouse what to do about their construction schedule. We just know that construction schedule impacts those milestones that we have to report to the commission. So yes, you can go back, and we asked for it repeatedly, but the answer was through 2014. They were revising the schedule. And yes, we thought it was a long time, but ultimately they said they got a schedule in 2015, which was the basis of the case in 2015. My team continued to say they never saw the entire schedule. They were limited to 1 week, 3 week, 6 week look-aheads. I'm not sure the term they use, but they're just small snapshots of the schedule. And as the case went on and Flora came on, there was going to be a fully integrated resource-loaded schedule that our team, that I don't believe ever, that schedule never existed. It was the basis of the 2016 case. So we did go for a very long time without a schedule. But once again, those BLR milestones are really what drives compliance for us. When we talk to SCE, when we talk to the commission and their quarterly report, they showed the delta between each one of those milestones based on the schedule information they have. In 2014, we stopped putting schedule information in our reports in response to SCE&G's reports, because we had no confidence, because they told us they weren't going to give us any updates. And if you want to understand what was going on with the schedule, we pointed you to SCE&G's quarterly report.
Didn't that trigger some kind of alarm bells in your staff? Say maybe we should go to the Public Service Commission and say we don't even have a schedule, and we've repeatedly asked for it. It hasn't been provided. We don't know when it'll be provided. Why didn't that happen?
And that goes back to the question earlier. Once we learned of that, we drafted letters. I believe they made it over to the commission, and then we asked for an allowable ex parte before the commission and say, we don't have a schedule. We're not getting this information. We know that several of them are close to 18 months. We had caution milestones. Anything that was greater than 10 months, we would bring to the attention of the commission in our report. We knew several were getting at 18 months if they hadn't already hit it. But that's why we decided to come to the commission and have that allowable ex parte, just to share what we knew.
It's kind of common sense. If you don't have a construction schedule, a project's in jeopardy, wouldn't you think?
I would say that. I believe SC&G and Westinghouse, and they would say they knew how to build a plant, and they knew what they needed to do.
Thank you.
Mm-hmm.
Thank you, Commissioners. Commissioner Elam.
Thank you, Mr. Chairman. Good morning.
Good morning, Chairman. Vice Chairman.
When you mentioned an allowable ex parte, it wasn't ringing a bell with me, and I went and found it. I think I found it. Was that have been from February of 2014?
That should have been the time frame.
Okay. I'm looking at the transcript, and I believe this is you. Let me just read something. It's page 5, around line 13. Although the BLRA requires the ORS to monitor the construction of the site, it does not require us to issue a report. ORS does elect to issue that report at the direction of our executive director. We do that to keep the ratepayers informed, as well as the commission informed of our findings. And when we work on that report, we have two primary monitoring priorities that we focus on, and here they are. They are SC&G's ability to adhere to the approved construction schedule and SC&G's ability to adhere to the approved budget. Does that?
That's correct.
Mm-hmm. Okay. And when you're talking about the report, is that a separate report, or is that your comments to the SC&G quarterly report?
That is a report, and I think we call it our review of SC&G's quarterly report.
Okay. And in his capacity as executive director, Mr. Scott directed the ORS staff to provide that every quarter?
It was, we would respond to SC&G's quarterly report. The way it would typically work, SC&G had 45 days after the quarter to file their report. And it typically took us 30 to 45 days to file our report. So,
when was the last ORS review sent to this commission?
I'm not certain. I'll have to check. We send them. I think they're certainly posted. I'm not sure if they're filed or not. That's a question for the attorneys back.
Would it have been clear up to the decision to abandon?
We have been providing our responses to their quarterly report. We just recently posted one.
Okay. So if I look at our files, I'll be able to find one for every quarter of the project.
Most of the project, we put a hold on those reports in 2015, I'm thinking, because of because of the 2015 update, what we were getting was SC&G's quarterly report reflected entirely the petition that they had filed. And without having the actual numbers, we had no way of comparing what the actual status of the project was in accordance with the approved schedule and the approved budget, because all the numbers were based on a petition that SC intended to file.
What do you mean you say you put it on hold? You suspended doing it?
We suspended doing those
For how long?
through 2015, I'm sure.
Okay.
Mm-hmm.
You said something going back, I think you may have said this to Commissioner Howard, you mentioned some safety issue with Mr. Solt on the site. Can you explain what you meant by that?
No, that was in response to Mr. Solt had the ongoing request to be allowed unfettered access to the site since he had essentially been working on construction sites his entire career. And SC&G did not allow that. Their response that it was a safety concern to having Mr. Solt walking around unescorted, and that could present some safety concerns for them.
Oh, okay.
I did not disagree. I did not want to walk around unescorted myself. So there's a lot of moving things, a lot of big things that could fall and hurt you. Yeah.
Did the NRC have unfettered access?
Yes, they did. As well as we learned that Bechtel had unfettered access as well.
Okay. You were asked about impairment a moment ago. I guess it was maybe Commissioner Williams. Is it fair to say that accounting rules determine impairment and not the company?
I don't. I'm getting out of my lane.
That's right. That's fine. I think that's all I have. Thank you, Mr. Chairman.
Thank you, sir.
Thank you, Commissioner Elam. Commissioner Whitfield?
Thank you, Mr. Chairman. Mr. James, just got one or two follow-ups.
Certainly.
One follow-up on one of Commissioner Irvin's questions, but one real quickly I meant to ask you earlier. How much interaction did ORS have with the federal inspectors from the U.S. NRC?
Not much interaction. We knew them casually through the public hearings that would be held in Jenkinsville.
But not much on the site?
Not much on the site, no.
And they had unfettered access and you did not?
That's correct.
Okay. Back to Commissioner Irvin's question or exchange with you about the schedule and that long period of time you described trying to get a schedule and not having one. And maybe you can do this off the top of your head, but in time frame, where does that correlate with CB&I exiting the project? Or I'm thinking those two overlap. Can you recall when they started exiting the project and your difficulty in obtaining that schedule?
Well, I think we talked about a couple of different schedules there. My recollection is that when CB&I came on board, they were tasked with providing a revised, fully integrated schedule.
Right.
And that's the one that took us through 2014. It was ultimately the basis for the March 2015 filing. That's the CB&I schedule. As we moved toward the end of 15, where the amendment to the EPC contract was presented before the commission, or at least signed by SCE&G, which became the basis for the 2016 case, Flora was tasked to develop a fully integrated resource-loaded schedule. And that is the change from CB&I to Flora.
Flora.
Mm-hmm.
As a construction manager.
As the construction manager and developing a different schedule.
In your answer about those quarterly reports to Commissioner Elam, you said the ORS stopped providing them to the commission because you couldn't verify SC&G's numbers. Did I understand that right?
Well, It was in two phases there. In early 14, SC&G informed us that the consortium wasn't giving them the schedule, nor were they giving, so SC&G couldn't give us the schedule. So there's no schedule updates that we would look at monthly, and that would prompt a notice or a letter or something to the commission,
Right.
whether you're getting closer to 18 months or not. And we knew at that time there were a couple that were already at 16 months. So we thought that was something of heightened concern that we should bring to your attention, and that's what prompted the allowable ex parte. As we moved into 2015, as you can see, there was a lot going on in 2015. The schedules, things were moving so rapidly at that time. If SC&G filed their quarterly report, so if something happened at the beginning of the quarter, you wait to the end of the quarter, you got 3 months, then you got 45 days after that. We'd get that report, then we start working on our report, and you add another 45 days possibly to that. By the time the report came out, it was so dated that we found little value in keeping the commission informed, and primarily, and also once again, like I said earlier, that the reports were based on a petition that was not approved. So our job was to report on a approved schedule and an approved budget, and the petition did not have that, or the reports did not reflect that. So there was not a lot of value there.
And that was about when that you recall that you stopped?
I think our last report we issued probably around mid-2015.
Last question. Let's fast forward past 2015. I know March 12th, 2015 is a big date, important date is ORS in ORS's eyes. But let's go just a little past that into 2016. And when we had the case in here, you recall the fixed price option contract case, which actually wasn't heard till the latter part of 2016. How confident was ORS? Of course, I realize you all stated you didn't know about the Bechtel report, but how confident was ORS at the time of that case that things would, for lack of a better word, get on a better footing and be successful?
And I wasn't heavily involved in 2016. Ms. Powell and Mr. Jones were our primary witnesses there. Mr. Scott took a leadership role there. I was busy with the Energy Office developing an energy plan for the state. But my recollection is that once again, when Flora came on board, everybody was positive. ORS was in support of the new nuclear units and continued to be. We thought that Flora, they were ones that helped build Unit 1. They were local guys. Things looked good. We supported it.
All right. Thank you. That's all I have, Mr. Chairman.
Thank you. Mr. James, just one question, probably a couple of parts. In your page 7 of your direct testimony, you just mentioned that the commission required a report from Baker Tilly. And I know we took a couple of shots at that. We asked once and it didn't quite cover the scope of what we really were asking for. So we went back at it again and got a little more information. So with that, did you use the Baker Tilly report to form your recommendations that you've given?
The recommendations for prudency? Certainly. Baker Tilly's report confirmed our belief that there was a limited chance for bankruptcy. But this report was prior to our testimony being filed. So the conversation was a little different. But we did have this as information we considered as we moved toward writing our testimony. Mr. Lane Collin, I believe, is our lead there. He'd be able to give you some more detailed answers.
Okay. And so I'm just wondering if you used it, why didn't you enter it as an exhibit to your testimony?
I believe the Baker Tilly report is already, I'll have to look at my attorneys, but I believe
Probably
it was,
wouldn't ask that if
I don't know. But we performed that, I believe, that's at the request of the pursuant to commission orders 2018-81 and 2018-102. So I think I thought you just had it.
Yeah, okay,
Mhm.
fair enough. Okay,
Mr. Chairman,
yes, sir,
I have a few more questions.
absolutely. Commissioner Williams.
Now, Mr. James, I really want to flesh out your position on this optimal plan. Because as a new commissioner, as I've gone through the testimony and listened to the in-person testimony, there's been a lot of talk about if we would have known something different at the time, we would have made a different decision, so forth and so on. And I think you would agree that any decision is only as good as the information used to make that decision.
Certainly.
All right. So as the energy director, you stand by the optimal plan.
Certainly.
Okay. But you do accept that there's a chance, even if a limited chance, that this optimal plan could create a situation where the company decides to go through bankruptcy.
I'm aware of that, yes.
Okay. And if that were to occur, there's a possibility, real possibility, that ratepayers would end up paying a higher rate than the optimal plan.
I would expect that to be the case.
Okay. And if that were to happen, would you still stand by the optimal plan as being the right decision for this commission to make?
Of course, in hindsight, with that information, of course, we would not have had. We would not think that would have been a good idea.
So, and this is where I get a little confused, because we know you've accepted that there's a possibility that bankruptcy could happen under the optimal plan.
Yes, sir.
And if that were to occur, then you would say, well, the optimal plan wasn't the best plan.
I believe our position is that bankruptcy is unlikely, but if there's the hypothetical that they do file bankruptcy, then of course there would be higher rates.
And so with all the options, other options on the table, is your testimony that the optimal plan is worth the risk?
Yes, sir.
Okay, thank you.
Mm-hmm.
Thank you. Commissioner Irvin.
I recall earlier testimony from Mr. Jones that just about every nuclear construction plant in the United States has had cost overruns. And so isn't it common sense that when a company like Westinghouse came forward and said, we will agree to a fixed price contract, shouldn't that have raised red flags? Because that's never been done before, has it?
I don't know. I believe the Vogel site had initially had a fixed price contract.
It fell by the wayside, though, right?
I believe that might be the case.
They're at $27 billion and counting. Is that right?
Yes, sir. Yes,
so
sir.
My point is this. You say you felt secure in it, but that was kind of a false sense of security, wasn't it, in a sense?
I believe everyone was concerned about it. And I wasn't involved, but there were meetings held with high Toshiba representatives that asserted that they would stand behind Westinghouse. I mean, you had everything you think you needed to make that decision.
Let's shift gears to your earlier testimony about impairment. Of course, that's all relative in the sense that there could be other things that the company might be able to do. For example, prior to bankruptcy, they could sell off assets.
Certainly.
They could reduce their dividend.
Certainly.
And they could even go to the legislature and ask for legislation that would allow them to refinance some of the debt. Some states have allowed that, but ours has no mechanism like that now. But if it could be demonstrated that it could save the company. That's a path forward too, isn't it?
Certainly, sir.
And you're familiar with some states that have done that.
If you're referencing securitization,
Yes, sir.
We did some research on that, and it's proven to be successful.
It works.
It works. Yes, it does.
Louisiana is one of the states that's done that.
Yeah, certainly.
How many states have?
I don't know if
About half the states, maybe?
I don't know.
Okay. But securitization would allow them to essentially refinance the debt
Certainly.
in a way that would give them a path forward.
Yes, sir.
And also, if they did go the bankruptcy route, and we all hope that would never happen, but if they did, there are some benefits to that in the sense that they could defeat a lot of these claims that are outstanding, all these lawsuits that are pending. They would be stayed in bankruptcy, would they not?
That would be correct. That's my understanding.
And a lot of the existing debt would be up to the bankruptcy trustee to decide and determine whether or not those debts would be compromised or extinguished.
I think you're getting a little above my head.
So anyway, I guess what we're saying is there are no guarantees. Nobody has a crystal ball.
Certainly.
But we want to do what's in the best interest of our state and our ratepayers.
Yes, sir.
And that's what we attempt to do. But nobody really can tell us exactly what outcome we'll have.
No one has a crystal ball.
Thank you.
Thank you. Commissioner Hamilton.
Thank you, Mr. Chairman. Just a short. Excuse me. Mr. James, earlier you just mentioned that the meetings with Toshiba. Did you or any member of ORS attend any of these meetings with Toshiba?
I understand our former executive director, Mr. Jones, was present, and maybe Ms. Powell was present, maybe Mr. Solt. It was a pretty big meeting held out at the site. And my recollection is Mr. Jones asked directly, can you absorb $1 billion loss? And the answer, well, we stand behind the project.
Do we have a copy of the report of that meeting?
I don't know if we have a copy.
We get one for that, Mr. Chairman. Appreciate it all.
Okay, late file exhibit number 35 would be that report.
Mr. Chairman, Nanette Edwards on behalf of the Office of Regulatory Staff. The conversation that you referred to, there would not be a report, but there was testimony provided in Mr. Gary Jones' pre-filed testimony and the testimony he gave from the stand in 2016. He put in his pre-filed testimony a description of that meeting. And I know Mr. James said the word Toshiba, but I believe it was a meeting with Westinghouse and Fluor representatives, and it was a Westinghouse representative. And I'm not introducing new evidence. I'm actually speaking from the pre-filed testimony that in the testimony in the 2016 hearing transcript. I can pull those pages and I can pull that testimony, and I can put that as the next hearing exhibit so that it's separated out easily for you to see. I know there's a lot of paper in this proceeding, so we can certainly separate that out for you.
That would be good, and I thank you.
Thank you, Mr. Chairman. Thank you, Mr. James.
Okay.
Thank you, sir.
Commissioner Howard. Cut it back on, Commissioner Howard. Cut it off.
Thank you, sir.
There you go.
Mr. James,
Yes, sir.
I don't know, I'm being redundant, but looking at the ex parte, Commissioner McGee asked, and you answered, we have ongoing contact with SC&G representatives at the site, and we also have quarterly meetings. As I mentioned with the Westinghouse representatives, those usually flow up to the project lead, which would be Ron Jones, who is assigned to the overall project. His authority is broad. It is directly linked going up the ladder through Jimmy Addison as well as Kevin Marsh. That tells me you had pretty well untethered access to the property with the leadership of the owners of the property, and I think you go on to say they've been very responsive. My question is, even though it was a safety factor, you're going to the site, if you asked, wouldn't they give you an escort at any time to go with you on the site?
I have, yes, certainly.
Okay, so basically you theoretically had unlimited access to the project.
We had unlimited escorted access. Yeah, right.
You could go wherever you wanted to.
If they could schedule it, they would accommodate us. I believe that to be the case.
Thank you.
Mm-hmm.
Thank you. Commissioners, anything else? All right, Mr. Ham, any redirect?
I'm happy to advise no.
Thank you, Mr. Ham. Okay. Absolutely. Mr. James, you may step down.
Mr. Chairman, if I may, we have a few follow-up questions that are raised directly from the questions of the commissioners. May I have the opportunity to ask those questions to Mr. James?
Can I be heard, Chairman? Can you hear me now, Mr. Chairman? I would object. The fact remains is the commission itself is the body that makes the final decisions. We all heard the questions. We heard the response. SC&G had the opportunity to tender questions, and I think now at this point, asking to ask questions based on what the commission was asking is inappropriate, and I think that puts I think we're now beginning to, this is an effort, I think, to change where the burden lies in this case, and on that basis, I would object to SC&G tendering any questions to this witness based on questions asked by the commission.
Okay. As I understand, he has the right to ask a question based on the commissioner's question, but he has to definitely make sure that it is related to the commissioner's question. Yes, sir.
That's fine, Mr. Chairman. Now that this is taking place, I want to reserve the right to redirect depending on whatever may come. Thank you, Mr. Chairman.
It's fine.
Thank you, Mr. Chairman. This is I'm John Challey, representing SCE&G. Mr. James, you said in response to some questions of the commissioners that you believed that the BLRA limited the ORS's review of issues associated with the project. Do you recall that?
It limited us to monitoring of quarterly reports filed by SCE&G.
Right, and it's important to that particular point that you were making in response to the question from the commissioner that you believe the procedures applicable to general rate proceedings don't apply in the context of proceedings under the BLRA. Isn't that correct?
I'm not sure if I followed that. That's a legal question you're asking me about rate case rules versus...
Well, there are procedures applicable to general rate proceedings that allow the ORS to audit the utility, to request documents from the utility, to employ experts and consultants associated.
Oh, yes, certainly.
And so is it your testimony that all of those procedures were available to the ORS for proceedings related to the project under the BLRA?
I don't know the answer to that. I believe when we're in a rate case mode, we're following the rate case statute. When we're in BLRA mode, we're following the BLRA statute, even though I think I understand where if there was a revised rates filing, some of those provisions apply. So
you are aware of the fact that SCE&G has never taken the position that the audit, inspection, procedures available to the ORS under general rate proceedings are not available to the ORS under proceedings applicable to the BLRA.
I don't know what SCE&G believed, but I believe that was their mode and behavior, certainly.
So
yeah.
They in fact did allow the ORS to invoke the procedures applicable to general rate proceedings on issues associated with the project. Isn't that right?
If you're referencing providing information in response to data requests that would be similar how we would respond during a rate case, yes.
And similar to the engaging of Mr. Jones. Mr. Jones was engaged under those particular procedures, and the ORS was able to engage him at the expense of the utility, correct?
I'm still getting a little confused because are you saying the work that we do at the site are bound by the same rules as a rate case?
No, I'm not asking you for any sort of legal conclusion. I'm just simply saying that the ORS invoked the procedures, the protections, and the tools, so to speak, available to the ORS under general rate proceedings in connection with issues associated with the project.
That's fair.
Okay. All right. So not only did the ORS invoke those procedures, but the ORS actually participated and settled the matters presented to the Commission in the 2015 and 2016 docket, right?
We did settle those cases. I think we've learned now that we didn't have all the information when we signed those settlement agreements.
So the final point I want to discuss with you, Mr. James, is the ORS, of course, didn't have to settle any of those cases. And you would agree with me, would you not, that the ORS could have told the Commission that the requests made by the utility in the 2015 or the 2016 docket should be denied because, for instance, the ORS didn't have sufficient access to the site, correct?
If we felt that was necessary, we felt we were getting all the information we needed. The limited access to the site didn't preclude us to come to the conclusions that we made.
Right, and same point for information on the schedule. So if the ORS concluded that it had insufficient information on the schedule, the ORS could have concluded in either 2015 or 2016 that it shouldn't have signed on to the settlement of those dockets, right?
If we had known that there was a Bechtel assessment and we didn't have that information, that there were estimates that SC&G's own team had put together that showed the cost to be $500 million more than they were presented to the Commission, we would not have entered into those settlement agreements.
So just to be clear, the ORS was aware in 2015 that...
Excuse me, Mr. Chairman, I'm going to have to
finish my
object.
question.
We're now going right back through questions that you all, several times, Mr. Chairman, you said enough was enough, move on. Well, apparently they weren't listening because they're not moving on.
Sustained.
Okay. Putting aside anything that the ORS knew or did not know, you would agree with me, Mr. James, that the ORS settled and resolved both the 2015 and the 2016 docket without raising any further concerns to the Commission regarding information that the ORS had at the time.
I'm sorry, Your Honor, Mr. Chairman, that's exactly the line of questions that they asked 20 times of Mr. Jones, and he's...
I agree. That's sustained. Let's move on from this.
Okay, that's all I have.
Thank you. Mr. Ham.
I'm happy to report I have no redirect.
Mr. Chairman, Will Cleveland on behalf of Coastal Conservation League and Southern Alliance for Clean Energy. I don't have any questions for this witness, but I would like a procedural clarification. You said that the company had the right to question him after the commissioners asked questions. Does that right apply to all the parties?
Mr. Butler just said, I'm afraid so.
Thank you, Your Honor. I don't have any questions right now.
It's not a real welcome addition.
I just wanted to make sure we had the right. Thank you.
Thank you. Just related to commissioner questions, though. That's strictly to commissioner questions.
Mr. Chairman.
Yes, sir.
Bob Gould for Friends of the Earth and Sierra Club. Just a suggestion. I frankly was a little bit surprised that an opportunity for recross was offered, and I know that the chair and others have encouraged us to move along and not delay the process, recognize how far we have to go. I just would, as a point of inquiry of the chair, I would be happy to forego all opportunities for recross at the risk of not having asked that last question that I would love to have asked in the interest of speeding the process along. But again, if recross is available to one party, it certainly tempts me to say, boy, I better make sure my client's interests are protected. And similarly with commission questions, I know that the questions appropriately were extremely extensive with this last witness, as expected. But I would have foregone the opportunity to ask follow-up questions after commissioner questions unless there was a really strong showing of a need to do that. And I just would say that from this party's perspective, expedition would warrant restricting recross and post-commission questions by the parties unless there's a strong showing of a need. And I just offer that as a suggestion.
Thank you. It's a good point, and you know, we're approaching having you all bring your families here for Christmas, so you know, I want to know who's going to cook the turkey. All right. Okay. What about Mr. Knapp? Well, if you've got something that's very related to specifically a commissioner question, that's the only recross you get. We'd rather move on. Thank you. Mr. James, you may step down, subject to recall. Next witness.
Mr. Chairman, Jeff Nelson for ORS. ORS calls his next witness Mr. Richard Baldino. Mr. Baldino, could you please state your name and occupation for the commission?
My name is Richard Baldino, and I'm a consultant with J. Kennedy Associates Incorporated.
Thank you. Are you the same Richard Baldino who pre-filed 64 pages of direct testimony in docket number 2017-370E on September 24th of this year?
Yes.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
I do not.
And if I asked you the same questions today as those posed in your pre-filed testimony, would your answers be the same?
They would.
Thank you. ORS asks that the pre-filed direct testimony of Mr. Baldino be read into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Richard Baldino will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Baldino, did you also prepare a cause to be prepared as a series of exhibits marked as exhibits RAB 1 through RAB 13, which were filed with your direct testimony in docket 2017-370E?
Yes, I did.
Do you have any changes, edits, or corrections to those exhibits?
Do not.
Thank you. Mr. Chairman, ORS asks that exhibits RAB 1 through RAB 13 be marked for identification, entered into the record of this case as the next composite hearing exhibit.
Okay, Mr. Baldino's exhibits will be entered as exhibit number 36.
Thank you, Mr. Chairman. Mr. Baldino, did you also file rebuttal testimony in docket number 2017-305-E on October 24th, 2018, in which you adopted the pre-filed direct testimony and exhibits in docket 2017-370E?
Yes, I did.
Okay, and do you have any changes, edits, or corrections to the rebuttal testimony in that docket?
I do not.
And if I asked you the same questions today as those posed in your pre-filed testimony, would your answers be the same?
Yes.
Thank you, Mr. Chair. ORS asks the pre-filed rebuttal testimony of Mr. Baldino, which was filed in docket 2017-305E, be entered in the record as if given orally from the stand.
Mr. Baldino's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. I'm not quite sure how this works, but I also asked that the exhibits which were pre-filed in the 370 docket and adopted in the 305 docket be made a part of the record, and I think they already were in the 370 docket, but just for reference, I would like that entered as well.
Okay, we'll enter those as exhibit number 37.
Thank you, Mr. Chairman. Mr. Baldino, do you also prepare 19 pages of surrebuttal testimony in docket 2017-370E, which were filed with this commission on October the 29th of this year?
Yes, I did.
Do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
I do not.
If I asked you the questions today as those posed in your pre-filed surrebuttal testimony, would your answers be the same?
They would.
Mr. Chairman, ORS asks that the pre-filed surrebuttal testimony filed in docket 2017-370E for Mr. Baudino be read into the record as if given orally from the stand.
Mr. Baudino's surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Did you also, Mr. Baudino, prepare a cause to be prepared an exhibit which you identified as ORS Surrebuttal Exhibit RAB1, which was filed along with your surrebuttal testimony?
Yes.
Do you have any changes, edits, or corrections to that surrebuttal exhibit?
I do not.
ORS asks that Mr. Baudino's surrebuttal exhibit RAB1 be entered in the record of this case as the next hearing exhibit.
Mr. Baudino's surrebuttal exhibit will be entered as exhibit number 38.
Thank you, Mr. Chairman. By way of introduction, Mr. Baudino, have you ever testified before the South Carolina Public Service Commission?
No, this is my first time here.
Could you provide the Commission with a summary of your education and your work experience in the utility business?
Mr. Nelson, time sort of got away from me. Before we get into this so we can get Mr. Baudino on a roll, let's take a little break.
Thank you, Mr. Chairman.
About 10 minutes.
Right.
Thank you.